Good morning. Welcome to Coffee with Connie. I'm Connie Fuchsa with Foote Title Group, where we protect your home ownership. Hope you guys are having a great start to your Tuesday. I really look forward to talking to you a couple of times a week so we can talk about all kinds of things that affect real estate. So today I wanted to talk a little bit about when someone wants to add you to the title to their property. What does that mean? Why do you want to do it? How does that affect you? What does it mean? We talk about this a lot, but I feel like this is one of the single most common questions I get from people. And so I wanted to help you understand some of it, give you the opportunity to ask questions, maybe talk about some of the pieces that you don't understand. So I know we're a little bit early today, but I wanted to try to get in to get a couple of things out to you today before the day got a little hectic. Good morning, Rhonda. Hey there, Sherry. Morning, Tony. Thank you guys for tuning in. Hey there, Pam. So let's talk for a minute. There's a lot of reasons why people may want to add or remove someone from the title to their property, but let's talk about specifically. I had someone ask me this question, and again, I love it when you guys ask questions because it helps. It helps other people. So if you have a question, ask me, because there may be somebody else out there that doesn't want to ask, maybe has the same question, didn't really think about whether or not who to ask the question, get the answer from. So if you have a question, feel free to reach out and ask me, whether it's privately or email or through our broadcast. So I look forward to helping you out. And this question came to me specifically from a friend who also is a realtor who knows some of the rules, but maybe not all the pieces. So she reached out to me and asked me. So her mom wants to add her to the title of her property for some estate planning purposes. There's nothing wrong with her mom. She's just wants to make sure that things go the way that she wants them to go if something was to happen to her. So only child. Her mom wants to add her to the title. Her mom's not married. So she called and asked me, so what are the steps? What do we have to do? How do we go through it? What do we need to think about? So let me talk about her situation specifically first, and then we'll talk about some other things, because there's a lot of different nuances that you may be thinking about. So your parents are maybe not elderly, but maybe you are an only child, or maybe you have some family members that are not the ones that your parents want the property to go to, and so they may ask you to go on the title to their property. So what does that mean? So first of all, let's walk through the steps of what has to happen. So we would take the information on how they own the property now, who actually owns the property, and then we would require something in writing that tells us who they want to add to the title to the property and how they want to hold title with that person or those people. So let's say, for example, in this scenario, mom's not married, so it's just mom who owns the property, and its daughter is the only other person that, the only child that the mom has, and so she wants to add her to the title. So in that case, we're just going to add one person, and at that point, are we going to add them, or are we going to just deed the property to the child? And so that question arises. Probably a lot of cases, the parent really wants to stay still on the ownership of the property, because why? They want to make sure that if something happens, somebody doesn't get along, whatever, something happens to the child first, which God forbid that happens, but it does, that the ownership is properly taken care of, that the mom doesn't have to go back through getting her property back. The property doesn't go through the estate of the child. So probably the best idea is to have the mom add the child, the adult child, let me say that. The mom add the adult child to the ownership of the property, because then the adult child is a co-owner with the mom. And a couple of things about that. So good morning, Shelly. Thank you very much for your feedback. I appreciate it. Hey, Mike, how are you? So let's talk about adding first. So what does it mean? Like, how do you own the property with them? So there's a couple of different ways. It's called tenancy, and it really is the rules about how you own the piece of property. So the tenancy is if you have two people and they're not married, there's two different options. You can do joint tenants, or you can do tenants in common. Now, the title company or the attorney working with you to get this taken care of is probably going to be able to best answer this for you and give you the best advice. But let me just walk you through the steps so you have the knowledge. So joint tenants means that both of you own 100% of the property. Now that sounds kind of confusing. How could two people own 100%? Well, what that means is if two people own the property and they own it 100% each, no one else can come in and make a claim against that ownership unless both people are involved in that. Number one. Number two, if something happens to one of them, the other one automatically already owns 100% of the property. So they both own 100% and neither one of them can do anything to or with that property without the other person. The other one is tenants in common. And tenants in common means that each person, in this case, two people, own a divided interest. Maybe it's 1/3, 2/3, maybe it's 1/4, 3/4. Maybe it's half. Maybe it's 2/3, 1/3. That's what I was trying to say at first. Got a little tongue tied. So there's a lot of different ways as tenants in common that people can own the property. But the problem with that is you own a percentage of the property. So if you take title to a piece and let's say it's 1/2, 1/2, you can sell your half, you can mortgage your half, a lien can be placed on your half that would affect that ownership. And the other person, if something happens to one of you, that half goes to the estate of that person that passed. So the surviving person would own it with the other person's estate. So that sounds awful confusing. Let's talk about it in the scenario we talked about. So you have a mother and a daughter, and the mother and the daughter own the property 50-50, 1/2, 1/2. The mother passes away, but they owned it as tenants in common. Then the mother's interest does not go to the daughter. It goes to anyone that has an ownership interest in her estate. So yeah, she's an only child, so she has a good chance of having the complete ownership. But let's say the mother had a brother and a sister and some nieces and nephews, and they have an ownership interest potentially in her estate, and that needs to be addressed. So it gets a little complicated if you own it as tenants in common. A lot of people do tenants in common, not immediate family members, but if you're doing things like you're buying something with a brother or sister or a friend, or you're doing some much more involved estate planning purposes, people will use tenants in common for those types of things. And one of the things to know about tenants in common is because of that divided interest, if someone gets a lien because they didn't pay their taxes from IRS or Maryland or Virginia or any state, these are all things that could affect that ownership. If you had a car accident and someone placed a lawsuit against you, it could affect the ownership of the property if there was a judgment. So tenancy is really important to understand how those different things would work. And of course, the title company or the attorney that you work with to take care of that deed for you can answer those questions and probably give you the best thoughts in that scenario. But I talked to you about it so you have the idea. So in this particular case, we have a mom, we have a daughter, adult child, and that is the only child. The mom wants to add her to make sure that her estate planning is properly taken care of. And so in this case, they're going to do a deed adding the daughter, not transferring it to the daughter because the mom wants to make sure that she still has ownership, but they're adding the daughter, and when they add the daughter, we're doing a joint tenants with a right of survivorship, which means, as I said, if something happens to either one of them, the other one owns it completely. But then the property is protected if the mother wants to make sure that the property only go to the daughter and not to any other of her relatives that could potentially have an ownership interest. So let's talk about other kinds of things. You own a piece of property with your spouse and you're getting a divorce and you're doing a deed and you want to take the spouse off because you retained ownership of the property, but you wanted to add one of your children. So that can happen. You just have to go through, again, deciding who you're going to add, how that's going to happen. And the other thing that you need to know is when we're talking about doing deeds, adding or removing people, if you're taking someone off the ownership of the property, that person has to sign the deed. It's the only way the title can transfer unless that person has passed away. The only way, or if there's a power of attorney for that person. If you have a spouse situation where you're getting divorced and through your divorce decree, one of the two of you got the property And so the one who didn't get the property leaves the area, you're not in touch anymore, and a couple years later you want to add someone else to the property, but you need to remove that spouse. That divorce decree does not take them off the ownership of the property. So you need to know that. Doing a deed to change ownership on property has to be signed by the current owners. So in the scenario I started with, the mother has to sign the title to that property, and she has to sign that deed changing the title or the ownership of that property. Otherwise, it's not a valid deed. And she has to have it signed in front of a notary, because a notary public has to witness the signature. So that person has to be outside of their home, or a notary has to go attend the signing. So if you wanted to add, let's say you wanted to add several children, maybe you were doing estate planning and you wanted to add several children. First, let me warn you, do not ever, ever add a non-adult child. Somebody has to be over the age of 18. You can do it, but it'll cause you a lot of headaches. If you ever want to refinance your property, you ever want to put a new mortgage, you want to sell it, you have to get a guardianship established through the court system for someone to be able to sign off on that child's behalf. You cannot do it. So do not add a minor child to your property. Only add your adult children if that's what you choose to do. So if you have several children and you want to add them all, that's all well and fine as well. You can add them all as joint tenants as well. You can add them all as tenants in common. It's just understanding who you want to add and how you want to do that. Now, when you do an estate and you do a will that that designates who your property is going to go to if something happens to you, that will serve as making sure that your property is directed as you want. The children may have to pay estate taxes, and they have to go through some processes. So if you only know that your property is going to go directly to your children and you want to address that, adding them to the ownership sometimes may make it a little bit easier. The one thing to consider is, we talked about this for a second, but if you decide later you want to refinance your property or you want to sell your property, if you add someone to the ownership, then when you do that additional financing or you want to sell it, those adult children have to sign off because they are owners of the property. So that's something to keep in mind when you start thinking about this. How is it going to affect maybe some other pieces that I want to do? And I think if you're in a situation where you have several children and you have your will set up, you might want to just go ahead and leave it through the will, because then it allows you the flexibility to do what you want with your property until you get to such point that maybe you know you're not going to be moving or doing any other financing. Maybe you're starting to have some illness or that kind of thing, and maybe that's a time to think about it. But you need to just keep some of these pieces in mind, because once you add them, then they have to sign off on other things that you do with that property, with that ownership. Good morning, Larry. How are you this morning? Hey, Phil. How are you? Hi, Sierra. So different ways to think about how that works, adding someone to the ownership or taking them off. Lots of things to think about. Certainly lots of things we can answer questions for you about. And hopefully we gave you a little bit of information that can help you if you have those thoughts, or maybe you don't understand it, or maybe you were thinking about it and you didn't really know how to go about it. Hey, John, how are you this morning? So I just wanted to reach out and talk to you a little bit about something that someone asked me about adding someone to the ownership of your property. The title, the ownership, all words that are a little bit interchangeable. They have a little bit different meanings, but for the purpose of understanding on a layman situation, they're kind of interchangeable. So I love helping you guys out with information. I love it when you reach out and ask me questions. Please do, even if you do it privately. And if you felt like this information was helpful, please share it with other people you know. It's the beginning of May, and as I told you, every month, my word is execute for the year. So the way I'm executing is providing you with new content every month to give you more information on the home buying and selling process. So later on today, we are going to be launching our next piece, so be on the lookout. It's something that you can go download that gives you information, and I'd love for you to go check it out. This weekend is our Make Yourself at Home in King George event that is at the King George YMCA on Saturday, May 6th from 10 to noon. It's free. All of the vendors there are all service providers in that community: fire department, police department, school system, animal rescue league, the parks and rec, social services, all these different community organizations that can tell you about things going on in that community. There will be free food and drinks, and bring your kids. The play zone will be open so your kids can go play with licensed counselors while you go around and talk. There will be demonstrations from the police department on safety and self-defense. So come out and check it out. It looks like it's going to be a great weekend, and come see what's going on in the community over in King George and get some free information and some free bites, and we look forward to seeing you. If you have any questions about any of that or anything we talk about, please reach out and let me know. Thanks so much for your time today. I really appreciate you tuning in, and I look forward to talking to you again soon. I'm Connie Foote with Foote Title Group, where we protect your home ownership. Have a great day, guys. Bye-bye.